SJC-12481, Solomon Carter Fuller Mental Health Center v. MC.
Ms. Kornblue, good morning.
Good morning, Chief Justice Gantz, Associate Justices. May it please the Court. My name is Deborah Kornblue, and I represent MC, the appellant. This case symbolizes how the fundamental integrity of the trial process and the adversarial system of justice was compromised when a court allowed an involuntary civil commitment trial to occur behind the closed, locked doors of the petitioner's hospital, which, as the court knows, is a place people go for treatment, instead of at the courthouse, which is an important symbol of equality in the American adversarial system. Courthouses impart neutrality and a perception that an independent and impartial judiciary will dispassionately adjudicate claims fairly. Courthouses are the places that the public normally associates with judicial and other governmental business. They impart a feeling of gravitas and formality that is just lacking in hospitals. The perception of neutrality and independence is absent when involuntary civil commitment trials are held in psychiatric hospitals or units.
What do you think of the amici brief from I think the Massachusetts Psychiatric Society, and also there was a letter from Attorney Thomas Schiavone, and I thought that both the letter and the amicus brief were getting at the point that there can be circumstances where a courthouse hearing could inure to the detriment of the person that is facing the commitment.
So, to address the concerns in their amici brief, both briefs go to great lengths to describe situations of alarmist examples of behaviors that people with mental health diagnoses might perform or conduct, how they will conduct themselves in a courthouse. They talk about elopement, they talk about assaults, they talk about all this extra security.
They also talk about overstimulation of the patient.
Right, that's true. They talk about that as well. But what's interesting is that in neither amici brief nor in this trial court's findings about what might happen if a person with a mental health diagnosis goes to the commitment trial, in none of those cases do we have one study, one case, one affidavit, or any other piece of literature or document that shows that any kind of behavior that they've described, any of these, exaggerated tragedies that might happen have ever happened. So they talk about that in many of the states, the legislature has allowed civil commitment trials to occur in hospitals. And the court, even in this particular case, talked about how when he was the first justice in the Concord District Court years ago, he used to have all the civil commitment trials in the courthouse. And again, in not one finding, in not one discussion about any of this, has any of that ever been documented. That's number one. Number two, to address some more of the concerns in the amici brief. There are at least 10 classes of cases that are regularly heard in courthouses, where the people who are the subject of these cases either have mental health issues, diagnosed mental health issues, or pose a high risk, or it's alleged that they pose a high risk of danger to others. So you have defendants in 209A restraining order cases. You have people who have already been civilly committed going to Superior Court and asking for discharge under Chapter 123, Section 9B. You have people under Chapter 123, Section 35 with dual diagnosis of mental health problems and substance abuse problems who might have been out on the street the day before getting high, going into a courthouse under Section 35 and defending themselves against a petition to hold them involuntarily. You have Section 123, Section 12E warrants, which are the same kind of cases, only for mental health issues. And you have people who are involuntarily held, usually before a petition for commitment is filed, sometimes not, who file a Section 12 application or motion for release from the same hospital where a few days later they may defend themselves in a commitment trial. Those are all held in a courthouse. You have sexually dangerous persons under Chapter 123A. You have people who are subject to dangerousness hearings under 276, Section 58A. And then you also have, which is very significant, 10% of the civil commitment trials in this state right now where they're all held in the hospital. So it really is not logical to say that all of those concerns are applicable to 90% of the people who have to defend themselves, let's say on the 7th floor of the Solomon Carter Fuller Mental Health Center behind locked doors, versus a hospital. So that's happening right now. With regard to whether the proceeding inures to the detriment of the respondent himself, there are procedures put in place, there are factors under the Americans with Disabilities Act that are built right into the statute, which this court has followed in the McDonough and Crowell case, where if someone feels that based on their disability, they need an accommodation, then they can ask.
But you're saying the opposite, right? You're saying that if someone wants to be mainstreamed, it's a violation of the federal discrimination regulations if they are not mainstreamed, aren't you?
No, what I'm saying is that.
Yeah, that's what I just want to make sure I understand. If I know you're saying the choice should be left to the individual. I take it you're saying that in all circumstances.
No.
So when isn't?
I don't want the court to have the impression that it's at the whim of a person whether they want to have their trial at the courthouse or a hospital.
Okay, but I don't get it then, because I thought you were saying if the person requests to be treated, to go to court, they have a right to do that, or it's a violation of the federal anti-discrimination regulations that you're referencing. Am I mistaken on that? Because I just would like to understand. Okay, then I just would like to understand what your rule is. Yep.
So what we're saying is that the default location, the default scheduling of the commitment trial has to be the courthouse. That's the non-discriminatory inclusion way of holding these trials.
So that meaning that right now, the default position is the opposite. You're
Correct.
saying that we should, as a matter of federal or state law,
Both.
reverse that, okay.
That's just a practice that has evolved.
I-
But what we're saying is people with mental health issues who qualify clearly under the Americans with Disabilities Act as people with disabilities should have their trial scheduled in a courthouse. Now,
But unless, because you're saying.
Unless.
Unless what? Yeah.
okay, unless, and this is where the contours of the limitations would come in under Section 5, Chapter 123, that would be unless they themselves, as the person with the disability under the Americans with Disabilities Act, request a reasonable.
I just asked you that, and you told me that it isn't always their choice. 'Cause you're now saying that it is,
Well,
has to be.
But it has to be tied to their disability.
Hold on, but I'm just trying to understand. If someone asks to be mainstream, meaning that they ask to be in court, do they have an absolute right to that? Or is there an
we're-
unless?
We're saying they should not have to ask to be mainstreamed.
Okay, but I understand your point right now that the default seems to be that 90% of the time we do this in the hospitals, and you're saying that raises all kinds of issues. I'm just trying to understand what is legally required. Does the Commonwealth have any discretion if the person at issue requests a court, or is it their absolute right to go to court?
No, there's an exception.
What is that exception?
So if, again, I just want to clarify, our position is they should not have to request. The default position should be their trial is scheduled at the courthouse like everybody else, so they wouldn't have to ask for anything.
Okay, I understand. That's
Okay.
another change that you would like.
Right.
Okay, but now I get
That
to
would
the.
be, in our view, the non-discriminatory way of
Right, so-
treating people
right, so
with
the default
disabilities.
position now will be you go to court.
With two exceptions.
Okay, go ahead.
Okay. So one is the person alerts his or her attorney or somehow alerts the court under the procedures that this court set out in McDonough, that they have a disability and that there has to be some kind of an accommodation made. Maybe the accommodation is that they can't go to court, but it might be something else as well. Maybe they just need a quieter time of day in the courthouse. Maybe they need somebody that they're familiar with to accompany them, possibly. Maybe they say, my disability is such that I,
Get that, go to your second one.
okay. If the petitioner determines that the person absolutely cannot be transported because they pose a direct threat, and that's, the definition of direct threat and all of the elements that entails is set forth in the Code of Federal Regulations, which I did attach to the reply brief. So if the petitioner can show that someone poses a direct threat,
Does that include to themselves or only to others?
according to the federal regulation, it's only to others.
So if the Commonwealth will have no ability to say that this is dangerous to the individual who's requesting to be mainstreamed, and unless that person poses a threat to a court officer or someone else in the public, that person has to be brought to the courthouse. I'm just trying to understand your rule.
That's what, yes, that's what the law is. And I mean, again, the same person is subject to automatically having his trial heard in a courthouse under Chapter 123, Section 12B, and under Chapter 123, Section 9B. And there never seems to be a concern about that. They're just transported to the Superior Court or to the District Court for their respective hearings.
And how is the court supposed to make a finding that the person poses a direct threat to others without having the very same hearing that we're talking about?
Well, the petitioner would need to file a motion with credible supporting documentation showing that the person has to have the hearing, cannot be transported safely to the courthouse. I want to point out, though, that in this particular case, this gentleman was transported at least 5 times that the record shows from the, either from the Brockton District Court, where his underlying criminal case was held, to either the Worcester Recovery Center, a distance of 53 miles, that was for his underlying competency hearing. And then after he was admitted to the Solomon Carter Fuller on around December 6, 2016, he was transported 4 times. Some of the times during the pendency of this particular case to the Brockton District Court, a distance of about 23 miles, and there's no evidence that there was any problem during transport or while he was in court, yet when he asked to have his trial at the courthouse, his civil commitment trial at the courthouse 2 miles away, the court said no.
Okay,
Ms. Kornbluh?
It was transported how? In the times that you described, transported in a sheriff's van?
He was in custody, so yes.
So he's basically shackled.
Well, that's how he would have to go, yes. But I want to,
Case of be careful what you wish for? I mean,
That's-
do you
if that's
want
how he-
individuals to be brought to court in shackles
well,
in a
many of
sheriff's
them would
van?
not, but if people who are subject to civil commitment trials under Chapter 123, Section 16B or C, or 18, are in custody, and if they make a determination that they don't want to be in the courthouse because of their disability, then they can request that. But to address your concern, Justice Gantz, a little bit more clearly, the statute itself in Section 21 and the concomitant Code of Massachusetts Regulation 104, Section 27, goes through very, very specific detail about transportation of people with mental health issues to and from various places, one of which is listed, the courthouse. And they talk about if there is a need for restraint, and these are people that wouldn't be shackled, but they talk about what they have to do, what the hospital has to do if they want to transport someone and they feel that extra security is needed. So they would have to ask the superintendent, if they would be allowed to restrain them. So hopefully that answers your question, but that's built right into the statute, and it's built right into the Code of Massachusetts Regulations about transportation of people with mental illnesses. Again, I just, do want to point out that in none of the other cases that I've described does this seem to be an issue, except when we're talking about people with disabilities, and specifically about people with mental health issues, and particularly when it's happening in 10% of the hospitals anyway, in 10% of the cases that are filed anyway.
Ms. Kornbluh, there's so many issues, and I know we're only getting to a fraction of them, but I expect when the Attorney General stands up, she's going to talk about mootness, which I'm not particularly interested in, but she's also going to talk about no attempt to reconstruct the record and opposition to expanding the record, and those issues are important. So if you could just at least take a moment to talk about that, because you're not going to be able to respond, at least orally.
So with regard to reconstruction of the record, it just should not, we would ask this court that it does not apply in this case for several reasons. First of all, the court, the clerk, and the clerk, to start with, took shortcuts ab initio in this case. This was right from the beginning. They started recording the trial, as you know, on an iPhone. So it was foreseeable that there was going to be a problem. And then when everybody became aware of the problem, shortly after the one witness's testimony, after she finished her direct testimony and trial counsel started cross-examining her, it became apparent that, that the recording device was just not being working properly, and that everybody knew at that point the clerk was using his iPhone. And so even at that point, it was foreseeable. So the ease with which the court could have complied with rules regarding recordation, take it out of the normal rules that this court has set forth in Harris and so forth about reconstruction. It would be fundamentally unfair to have someone alert the court, as MC did through his attorney, before trial even starts, hey, this is a problem, we want our trial in the courthouse in part because of this very problem. The court summarily said no, as apparently the courts summarily do when everybody asks to have their trial in the courthouse. And then to say, we alerted you again, we objected again, and the court decided to go ahead and use substandard recording equipment anyway. And now that you know the transcript is insufficient, now you have the burden to fix it. So that takes it out of the normal rules of reconstruction. Additionally,
Can I ask about the fact that this happened on the 12th day and they had to have it on the 14th day? The motion to go to court doesn't happen right until we're 12 days into the 14-day time period. How do we deal with that?
you mean the motion to move the hearing to the courthouse?
Yeah.
Well, again, what we're hoping is that MC, and forgive me if I forgot to announce, but my trial attorney is present also today with me, Ann Keeley. I don't think I said that initially. Hopefully, that kind of a motion would not need to be made because the default would be at the court.
Going forward,
Right.
that may be true, but in your case, it's sort of popped on the judge, and he's also got a 14-day time clock that's about to expire, right? Makes it difficult to wrestle with that at the last second, doesn't it?
I don't see that that would be difficult. First of all, the trial attorney filed the motion only 5 days after she was appointed. And so it's hard to see that she could have done that any earlier than she did.
I'm not criticizing her so much as I am focusing in on the fact that the judge has to act within 14 days.
The judge is at the courthouse anyway.
Yeah,
So,
but the hearing is already scheduled for the hospital, correct?
the hearing was scheduled for the hospital, yes. And it was continued, the record shows, for about 3 or 4 days. I think that it would have been logical or easy to have the court hear this trial at the normal place where the court normally conducts trials. It was filed the day before the case was originally set, that's true. So what we're asking is that the court, this court, reverse the appellate division's decision finding that the appeal is moot, reverse the trial court's denial of the motion to vacate, which was brought again for the 3rd time, raising these issues, reverse the order of commitment, and hold that all civil commitment trials should be scheduled at the normal place where litigants have their trials, which is at the courthouse. Thank you.
Thank you.
Ms. Walker, good morning.
Good morning, Your Honors. May it please the Court, Celia Walker on behalf of the Solomon Carter Fuller Mental Health Center. This case, as presented by MC in his Rule 60B motion, in his application for direct appellate review, and in his principal brief, was about whether or not the trial court abused his discretion, or the trial judge abused his discretion and violated MC's constitutional rights as a result of his response to a malfunctioning recorder. It is evident that in MC's reply brief and by virtue of the many amici briefs filed in support of his position that there's an effort to transform this into something much larger than that. I would strongly encourage this court to reject that invitation. It essentially appears to be a Chapter 211, Section 3 case involving the district court and the Boston Municipal Court's practice of how it exercises its discretion with respect to scheduling these hearings. The district court.
Are you saying that issue isn't before us, or are you saying we should decide the simpler, more straightforward issue? I'm trying to understand whether they preserve this complicated issue as opposed to they backed into it.
It definitely is not properly before the court, Your Honor. It definitely didn't make it into a principal brief. It was not raised at the 60B. I looked into the record that she didn't provide to this court, and it wasn't, the ADA allegation anyway, it was not raised at the appellate division. So certainly the question of this broader issue of the trial court's practice has not properly been before this court. And the district court certainly and the BMC should have an opportunity to present its case, what it would say in response to these many factual allegations. I do want to say that that does not mean that the issue about the adequacy of the courtrooms that are provided at facilities is an unimportant one. The issue should, of course, be explored. There's fair debate that's outside of the record as to whether or not those courtrooms are adequate, but the courtroom in this particular case has not been described in any way that seems to me to be inadequate or the department.
What about as to the big picture here? We really haven't talked about it a lot, mentioned in at least one of the amici briefs. So the big picture, I think, from the perspective of the respondent, is that there's a bias that goes on that the district court judge and the BMC judge might not even know about. They might not even recognize because of where the hearing is taking place, the way that the respondent is dressed. I did these hearings. I did many of these hearings.
I'm aware of that, yeah.
And I thought about it a lot after it was raised in the amici, trying to put myself back 18 years ago when I was doing these hearings. And you walk into Bay Ridge and you start to do the hearings, and is there something about the mindset of the trier of fact that is unfair to the respondent? Is that before us in this case?
I really don't think it is, Your Honor. I think that that's first of all, that is a study or allegations that were put in as an attachment to amici brief that, again, we have had, the district court and the BMC have had absolutely no opportunity to respond to. I think I can say more narrowly that certainly the issue of bias arises, as it did in the Foley case, more when you're talking about a jury. And the assumption when judges take the oath of office and put on their black robes is they're operating by the rule of law and objectively.
Yeah, but there's always, I mean, I think we all know there's always the implicit bias that you're not really tuned into that can happen to the trier of fact.
And I would submit, Your Honor, that if that needs to be explored, if there needs to be studies that are, I know of none, but certainly on this record, I don't think.
And
that
on
you
the
can
other
go there.
hand, I know that there's issues and concerns about how long a psychiatrist or key personnel are going to be away from the institution. Those are also concerns that have been raised that are serious. Do we have enough information about that in front of us?
Other than what I would say is purely logical, which is that if you have a situation where I would submit it is a reasonable accommodation request, where you have a decision where they have hearing days, right? So like, for instance, in Bridgewater, there can be up to 25 in a day. So let's say you have 5 respondents that want to have it at Bridgewater and 10 that want to go to a courthouse, and it's the same treating psychiatrist. I don't know that you need a whole lot of evidence in the record to conclude that that would be incredibly difficult. And I do just want to use this opportunity to bring to the court's attention the Olmsted case, which is, of course, the seminal case around integration and mainstreaming, as you were discussing, Justice Kafker. And I would highlight for the court and urge the court to look at Olmsted, because the opening paragraph, Justice Ginsburg writes on behalf of the court, and this is on page 587, 527 U.S. 581 at 587. The opening paragraph, she discusses the fact that what's before them is whether or not to provide these, whether or not to integrate individuals with mental disabilities into community homes. The answer, we hold, is a qualified yes. Such action is in order when the state's treatment professionals have determined that community placing is appropriate. The transfer from institutional care to a less restrictive setting is not opposed by the affected individual, and the placement can be reasonably accommodated, taking into account resources available to the state and the needs of the others with mental disabilities. And I think that that's very, very important in this case. There's a lot of statements being made about how this is a broad discrimination against all individuals with mental disabilities, and I submit that that is absolutely not the case. The district court and the BMC do not have an individual walk in the door who is suffering from a mental disability and say, you have to have your unrelated to a commitment petition hearing over in the facility. That would be.
But isn't the default position that it happens in the facility?
It is, Your Honor.
And I think they're arguing that's a legal problem from the federal perspective.
Well, I'd actually like to backtrack on what I just said, which is that it's a default in the sense that, as I understand it, many district courts in the BMC find it most administratively possible, and it functions better to have it at the facility. That being said, there are district courts who, as a result of their needs, administrative needs.
I'm just looking at the statute itself. Hearings may be conducted away from, it's the court rule. Hearings may be conducted away from the courthouse and at the petitioning mental health facility. Normally, it is desirable to do so. I guess I can't tell whether the fact that we sort of start in the hospital and then only back into the court is a legal problem from the federal perspective when the defendant, or I'm not using the proper term, when the individual requests that it be in court. Can you answer that legally? A person requests a court hearing. I know you say that's not properly preserved here, and that's a very important issue that I got to reread all the proceedings, but person requests to be mainstream. They want to go to the court. And if the default is the opposite, is that a federal anti-discrimination problem? Because it does seem a little odd. And there may be very good reason for it, but the fact that we sort of start with the hospital and not the court does seem strange.
Well, I think it's only strange when one doesn't have a lot of the information that I've been told since taking on this case of the perspective of the BMC and the district court and how they manage over 5,000 cases
So does
of
that
these a year.
suggest we should, if they didn't just throw it in at the last second, if it's properly before us, should we remand it and develop a real record on this then?
I mean, That, or it should
be
be addressed
possible?
as a separate petition. I mean, this is a broader issue dealing with the district courts and the BMC's administration of the court system. I would also just remind the court that both Chapter 220, Section 5, and Chapter 218, Section, I believe, 38, allow the courts, the trial courts generally, to decide the locations of where they're having their sessions.
So
I
on this-
understand.
But it's a little different if you're Framingham District Court versus, Natick District Court or whatever, I'm making these names up. But as opposed to Framingham District Court and, a mental health facility, or even a homeless shelter. I mean, there may be very good reasons why you're doing this, but when it's over the objection of the person, then it starts getting complicated.
Well, I think in this particular case, because that is the only evidence we have right now, although I've been told lots of other evidence, in this particular case, it is, of course, an abuse of discretion review. In this particular case,
I understand, you both agree it's rational basis under state law, but if it's a federal anti-discrimination issue, that changes things, right? I'm not sure we're not deferring to our rules and regulations there. We've got to decide what the feds require us to do.
yes, Your Honor, and I would say that the MC and the amici are sort of blurring two different components of the ADA. The first, of course, is the reasonable accommodation claim, and under the reasonable accommodation claim, you do have to meet this threshold issue of whether other and non-disabled individuals are entitled to the service that's provided. And I think both MC and the department or council agree, at least she said so in her reply brief, that the service being provided by courts is a fair hearing.
I get the accommodation point if you request it, but a lot of disability law is fought out over, I don't want to be accommodated. I want to be in school with everybody else.
So more the integration issue.
Right.
And there I would highlight for the court the Olmsted part that I read. And there, the court went on to say on page 602.
And some of the judges here are better at doing this orally than I am, but when you read Judge Ginsburg, I thought she said they were requesting the accommodation, not opposing the accommodation in that case.
She was saying first that, and she later elaborated on it, that the state is allowed to rely upon mental health professionals. And so the issue.
Over the objection, because I thought that was a case where the person was requesting the accommodation. Here, they're doing the opposite. They don't want to be accommodated.
I think it's an important distinction, though, because there, again, Your Honor, you're combining both accommodation and integration, and those are two separate issues.
Right.
But even with respect to the integration, the case law, and I can't come up with a case right now, but it is in my brief, makes clear that the same defense would apply, the undue burden and the fundamental alteration would apply to any request for mainstreaming, as you call it, or the integration. And that is made clear in Olmsted.
Say that would apply that. Undue burden on who?
On the state. And in Olmsted.
Does the state have to establish that it would be an undue burden to mainstream the person?
Yes, it is. The case law says that the initial request, and again, this is in the accommodation context. I haven't seen it in the integration context because Olmsted, its framing of it is a little bit different. But at least in the reasonable accommodation context, the request that's being made for an accommodation has to be facially reasonable. In this case, I would submit, first of all, that MC states in her reply brief, or in his reply brief, that he didn't request a reasonable accommodation. So it's also not before this court for that reason. But secondly, I think one could certainly argue, although I didn't do so in my brief, that she didn't make a facially reasonable accommodation request. You have hearing dates. There was.
But the accommodation is what you gave her. She didn't want it. She wanted what everyone else gets, court. And
Well,
I'm just wondering whether, is there a burden on the Commonwealth of some sort to, you talked about this undue burden. I get it, this may be very burdensome and problematic and also impossible for the reasons the chief brought up, which is you need a hearing to determine some of this stuff. But I just don't know if the burden is on the Commonwealth as opposed to the plaintiff here. And if that's the case, is our default rule problematic?
Well, I disagree with the first part, which is that
I'm
this
not-
is even
I'm not saying that's accurate.
I don't think that the court was giving her an accommodation by coming to the facility. I think the court was exercising its discretion about where to have its hearings. And it was doing so the way it would do in all cases as to what makes sense, both with respect to administration of justice issues we talked about in terms of homeless courts or any other feasibility issues that relate to how the district court or the BMC is going to manage its docket. The fundamental alteration here would be the removal of that discretion. And so she and I have a different view of what is the accommodation here. Yes, sorry.
No, that's okay. I just want to move off the ADA for a moment and get to the due process issue and the rational basis. In terms of what's before us, what should we try and are able to address in this case? Because you've referenced a lot of these issues that also are important in trying to understand whether there's a rational basis or not to have the hearing at the facility. So along those lines, when you're dealing with something like that, you need a record. Are we in a position to be able to do a rational basis analysis with what we have before us?
Well, the rational basis, the limited rational basis analysis would be with respect to the recording mechanism, whether or not she has raised or there is before you a potential due process violation as a result of the recording mechanism that was used. That was the case that that counsel submitted.
Along those lines, that would mean whether or not, in this particular instance, you'd first have to address whether or not the record was inadequate.
Well, I think what Harris says and what the cases after that say is that you can have the word was not exactly reconstructed, but you can have a record that satisfies due process that is not an exact transcript, and that.
But before you get to, you have to have the record be inadequate before you can go anywhere else, don't you?
Yes, and here, I mean, the way that we get there is through the rule about, in other words, if this was an appeal from the denial of a motion to reconstruct the record, it would be a completely different case. But in this case, she didn't attempt to reconstruct the record, and what we know from that is that you have to then show. You can't just rely on a structural error doctrine. You have to show in what way you were prejudiced by the record that does exist. And so I don't think that in this case, the narrow due process issue that has been presented, I don't think you need to remand for that. Nothing in this transcript, she has not identified anything that was missing that would have been critical. She makes broad statements about critical evidence and actually doesn't identify any. So I don't think there is a due process problem here.
But as to the bigger equal protection issue, what's your thoughts on the record?
On the record, again, she has focused on recording.
Beyond the recording. So you would say.
Beyond the recording.
Right. You would say that we should not address, at least on this record, equal protection issue beyond the record, or you think we have enough information to do so?
Well, I think that as a matter of law, one can say that if she's arguing that Chapter 123, Section 5 violates, violates her rights to, or his rights to equal protection, then you would look at whether or not there's a rational basis for that. I would just point out, as I did in my brief, that Section 5 simply reiterates what exists in 220, Section 5 and 238 about giving the court discretion as to where it holds its hearing. But that being said, I think it's very important to point out, as I did earlier, that we are not talking about evaluating whether or not a statute meets the rational basis to test as to whether it is discriminating against all individuals who suffer with some sort of mental disability. We're talking about individuals who are in need and have been found by a mental health professional to potentially be in need of acute inpatient care. That's the starting point. The point of the hearing, as you know, Justice Lowy, is to determine whether or not the standards of Chapter 123 have been met. But I think it is important to keep narrowing in on the fact that this isn't a discrimination against all individuals with mental illnesses. I wanted to just use, if I may, a hopefully helpful hypothetical, which is that it seems to me what they are arguing would be if you used the diagnosis of epilepsy as an example, that you are not discriminating against all individuals with epilepsy if you say you are having seizures, you can't get on the road. You're saying as this particular condition is manifesting right now, we can't have you on the road. That's what it means. It means in these particular individuals who are diagnosed with a mental illness are potentially in need of acute care. That's the threshold decision that's been made by a mental health professional. Olmstead says...
How about your epilepsy hypothetical?
Sorry?
Let's take your epilepsy hypothetical, because they're not really dealing with that. They're saying whether the person who's got epilepsy has to have their hearing in a hospital as opposed to having a hearing in court. Now, they may have all kinds of problems in court, but the bigger issue is driving them there, right? I mean, and can someone drive the person with epilepsy?
Well,
I worry about your hypothetical a little bit.
It's limited. The point I was trying to use it for, Your Honor, was to say you can't conflate discrimination against all individuals with mental disabilities when what's going on is actually a sort of what might call a subset. It's the symptoms that that person with mental disabilities is experiencing that a mental health professional has said puts you in this position where we're not sure if you're safe to be either to yourself or others to be out in public. And that's the way that I'm using it. I understand that whether or not you wait 6 months to get on the road and have your license is different from where you have your hearing. My point is just it's not a discrimination broadly against all individuals with mental illnesses in the same way that we're not saying just because you have epilepsy, you can't drive.
Can I ask just one last question on CFR 35130B? The appellant argues that the court denied the appellant the opportunity, quote, and she's quoting right from the reg, the opportunity to participate in services, programs, activities that were not separate or different, despite the existence of permissibly separate or different programs or activities. So I think, why isn't this in violation of that? Because they're saying you could have separate but this person was deprived of an opportunity to participate in the ordinary process. Is that, yeah. And maybe she's cutting and pasting from CFR 35130B, but it seems to be on point.
See. I mean, I would say, again, that that's certainly a new issue that's been raised. It certainly was not raised in a principal brief, but I understand that's not.
Okay, all right. I maybe have gotten that from one of the...
To me, it sounds like a variant on the integration issue that Olmstead addressed, but I'm sorry, I'm not more prepared to answer that.
Before you step down, was this hearing open to the public?
Yes, it was, Your Honor.
And how do we, do we not have some superintendent's authority here with regard to ensuring that even though it's in a mental facility, it's still open to the public, even though the mental facility is not generally open to the public?
Well, I think that, you always have superintendency authority, but I would remind the court that Kirk itself took place in a facility. That the notion that these hearings should be open to the public, that case took place in a facility. And so I don't think there's any, I walked in
I thought the judge here said it was closed.
No, in the Rule 60B motion, he made an error of law saying that these hearings are closed. But there's no evidence that at the time of the hearing anyone was told to leave or that there was someone who requested to come in. There's no allegation on her part or claim here that she was denied the right to have anyone present or he was denied the right to have anyone present that he wanted there.
But pragmatically, I'm just trying to see how this works out. You can, obviously, anybody can walk into a courthouse, but I don't know that anybody can walk into a mental facility.
Well, outside the record, I can say that's exactly what I did. When I went to Worcester, I decided after receiving the amici, I would go and try to sit in on some of these hearings. You have to go through a metal detector to get into the courthouse. That's what happened to me. I showed my bar card, I went in, it was no problem.
Okay, but if you don't have a bar card, you don't know.
There
We don't
seemed to
know.
be no problem. I mean,
And-
there
and-
wasn't a metal detector, I can tell you that.
But in
People were-
in terms of our superintendent's authority, do you agree that if a court is going to conduct a hearing at a mental facility, it needs to take appropriate steps to ensure that that facility is indeed truly open to the public?
Most certainly, Your Honor.
And we must not be doing that well, because you got a very experienced judge, who's been a judge for a long time, dealing with a Rule 60B motion, and he thinks that it's a closed courtroom. So if he does, with all his experience, then we must not be doing a very good job to get the word out that it is open.
Well, I'm being redundant, I'm sure, but first of all, I don't think that's the case with the members of the judiciary that I've spoken to. The judicial standards make it quite clear that these are supposed to be open to the public. I would just point out, Your Honors, that there's a lot of focus that has been made as to whether or not being in the courthouse would automatically give more public access. What Kirk never did do was sort of reconcile what 123, Section 36A, which has to do with the confidentiality of all the documents, how that fits with the Kirk rule on there being public access. So as far as I know, 36A applies to dockets. It could very well be, and I think it may be the case, that if you go into a courthouse, it's not clear that you would know where there's a civil commitment hearing happening.
But doesn't 123, Section 5 require, it says expressly permit public access, so they've got to be set up to allow the public in, right? I mean, whether the
Are
judge
you talking
was-
about the courthouses or the?
No, all court hearings, 123, Section 5, doesn't it provide that if you have it outside of a normal court, it has to permit public access, doesn't it?
Well, certainly Kirk says that.
I'm not even relying on Kirk, I'm relying on the statute. It says all court hearings should be held in rooms of adequate size and appropriate condition. The physical setting must be sufficient to provide for appropriate security, permit public access, and elicit the customary respect according to court proceedings, right? So
Yes, Your Honor. So maybe that must be where Kirk
Yeah, gets it.
got it.
Yeah.
But I don't think there's any question that it's settled at this point. Certainly, the district court and the Boston Municipal Court standard are clear that it's settled, that they should be open to the public, unless, as Kirk pointed out, there are, if there's a request to close the hearing, which is, of course, what Kirk was about, there are certain, tests that the court needs to go through to evaluate that request.
Again, going back to our superintendent's authority, do you agree that the recording system, I should put that in quotes, that was used here is not a tolerable recording system for such hearings?
Yes, Your Honor. A cassette recorder, if it's not used generally in, well, let me put it this way. Certainly, the department is not advocating or taking the position, I should say, that hearings that happen in courtrooms at the facilities should meet a lesser standard than what exists in a courthouse. As I understand it, currently, digital recorders are the norm. What happened in this case was a malfunction. And so I think...
Rather, it was not digital. If the recording was older than anyone in the courtroom, I doubt it was digital.
Yes, and from my understanding, it was because there was a second hearing going on. But again, that's outside the record. So the general practice is to have a digital recorder in effect. Again, it could be, based on what the amici have submitted, that there are certain courtrooms at facilities that don't have digital recorders. Again, that is, as you mentioned, Your Honor, maybe a separate case. Maybe it's a 211 Section 3 case. But it's not this case. And I don't think we have sufficient evidence at all, one way or the other, to say whether or not the amici's experience is pervasive.
Now, you also say the case is moot, but what do you do? Nobody seems to have cited our recent case of, in the matter of FC.
Yeah. So I actually was not going to start with mootness, Your Honor.
You'll end with it, but
Yes,
go
my
ahead.
moot court made very clear I should skip right past that. But the point there was that FC, I think, did leave some room. It talked about stigma in this case as what would defeat a mootness argument. I do think in this case it is possible to say that stigma already exists no matter what. He was recommitted. He had been committed previously. For that reason, it could still be determined moot because he isn't experiencing any existing harm that could be remedied in this case. But certainly it was not my lead argument.
Okay, thank you.
Thank you, Your Honors.